judges, and the National Intelligence Service has disowned a document that formed part of a report that the Judicial Service Commission heavily relied on to indict Supreme Court Judge Justice Philip Tunoi. The NIS, as a response to a request by Tunoi's defense, dismissed a document that formed the basis upon which the formation of the Tunoi Tribunal was based.
For JSC, I'll tell you.
The authenticity of a so-called classified document presented to the tribunal last week would form the basis upon which Tuesday's session would commence. The National Intelligence Service had been asked by lead counsel to the tribunal, Paul Nyamodi, to indicate whether a document presented before the judiciary's ombudsman had indeed originated from the spy agency. The document allegedly highlighting evidence of frequent contact between Geoffrey Kiplagat, the whistleblower in the case, and Supreme Court Judge Justice Philip Tunoi. NIS insisting that no such document came from them.
This is the document that was the center of our challenge and which now NIS say did not emanate from them.
Kennedy Bidali, the ombudsman to the judiciary, appearing once again before the tribunal, would be at pains to explain why his office took up the matter of initiating investigations into Justice Philip Tunoi's conduct as opposed to the Judicial Service Commission.
This process that was initiated by you, internal process, it ends when?
It ends on 26th January 2016.
Very good.
Our internal processes.
What do you do on 26th? You give a report to the Chief Justice.
Yes.
After that report, you appear before a select committee of JSC.
Correct.
Up to there, could we conclude by saying that is the initial process internally initiated by you?
In the ombudsperson's office?
As ombudsperson.
Yes.
According to Tunoi's defense lawyer Fred Ngatia, Article 168 of the Constitution of Kenya indicates that the removal of a court judge ought to be initiated by the Judicial Service Commission as opposed to the Ombudsman's office.
I thought a minute ago you told me you are the investigator requested by the Chief Justice, Willie Mutunga.
Yes.
Do you want to change that process?
No, I am not changing the process, and that's why I'm telling you. It is impossible to answer that on a yes or no basis.
Is this affidavit addressed to JSC? Yes or no?
Like all affidavits, it's sworn under the oath and such.
I am not interested in other affidavits. Is this affidavit addressed to JSC? Yes or no?
It has no address. It's not addressed.
It's not addressed.
JSC.
So I have first and foremost a constitutional difficulty understanding you, the Chief Justice and JSC, because you embraced a process that has no business with you.
Bidali's testimony would also undergo sharp criticism by the defense, who poked holes in the manner in which investigations by his office were conducted.
You are just being very reckless, just dropping accusations against your very senior judge. Why not make the most rudimentary effort of trying to find out?
We did.
Did you ascertain?
I did.
Did you ascertain whether he bought the land?
Personally, no, Chair. As I said, in the course of processing, there are many issues that were beyond our mandate.
By the time you're giving this evidence, had you ascertained whether that is true or not true?
I had asked the other state agencies to do that, to make that follow-up, and their reports had not come back to me.
So the Sharad Rao-led tribunal will once again be seeking to hear from Kennedy Bidali in his two roles in this matter. First, as the ombudsman to the judiciary, and secondly, as the chief magistrate at the Milimani Law Courts, with Tunoi's defense team insisting that according to the Constitution, a chief magistrate from a lower court cannot initiate investigations against a judge sitting at a superior court. Timothy Otieno, KTN News.